10-year-old Linus recently entered the child welfare system. The local Children and Youth Agency places Linus with a foster family. The children and youth caseworker learned during his investigation that Linus has an IEP. The caseworker and Linus's foster mother each contact the special education teacher at Linus's school to obtain a copy of Linus's IEP. They tell the teacher that they want to be included in all future meetings at the school regarding Linus. Later, the caseworker and the foster mother both attend an IEP meeting for Linus. At the end of the meeting, the special education teacher asks the caseworker and foster mother to sign the IEP on the line parent-guardian.
Great, thank you so much. Okay, so again, let's start with the basics here. It's clear from the scenario that the person who has information that someone else wants is the special education teacher at Linus's school. And specifically, it's the agency caseworker and Linus's foster parent who want the information. And they want to get a copy of Linus's IEP, and they also want to be included in future IEP meetings. The scenario in terms of the question, what does the requester want to do with the information, really doesn't spell out, but presumably the caseworker and the foster parent want this information because they want to make sure that Linus is getting the education and educational supports he's entitled to under his IEP and give input at the IEP meetings. So what laws pertain to Linus's IEP and to the ability of the foster care worker and the foster care parent to actually attend the meetings? IDEIA is one and FERPA is the other. Both laws are in play here because remember, with respect to special education students and their records, the IDEIA says you look to FERPA first. You look to FERPA unless there's a specific provision in IDEIA that is applicable. But basically, it's the FERPA provisions that would apply to the records, and then the ability of the rules with regard to who can attend IEP meetings and who can sign the IEP would be found in the IDEIA. So let's talk a minute about just getting access to the records. First of all, the county children and youth caseworker, the child welfare agency caseworker, have the ability to get access to Linus's IEP without getting Linus's natural parent or legal guardian to sign an authorization? Yes, according to the USA, to the Uninterrupted Scholars Act, because again, that law says that if an agency caseworker a caseworker with an agency that has legal responsibility for the care and protection of a child, as that's defined under state law, who also has access to the case plan, can get the IEP and other school records from the school without a parental authorization. What's unclear is it looks like under the USA the foster parent would not be able to get the records from under this exception to FERPA. So far, the people who have interpreted or issuing interpretations have not included foster parents. So it looks like, though, that if the child welfare agency has a policy that says that the caseworker should be or will release information containing education records to foster parents, then the caseworker could give the foster parent the records themselves. The other question here is about who can attend the IEP meetings and who can consent. So basically, what the IDEIA says is that the parent is the education decision maker for a child with regard to their special education records, and as also their special education decision makers. So the person who falls under the definition of parent can request evaluations, request IEP meetings, sign the IEP, get notice of the educational placement. They're the ones who can exercise all the procedural rights to appeal all of these decisions and placement decisions, and they're the ones who get access to records. So it's important to know how the IDEIA defines a parent. Basically, it can be a biological or adoptive parent. It also can be a foster parent if the state law permits the foster parent to act as the parent under IDEIA. Or it could be also a person who has been legally appointed by either the school district or a court in a child welfare case to act as the surrogate parent, the educational decision maker. So in this scenario, I've been told that under Colorado, there's no explicit Colorado state law that says that a foster parent is considered a parent under the IDEIA. Is that correct from people's understanding? I understand that a foster parent can be appointed to act as an education decision maker by a court or a school district, but they don't just automatically have the right under Colorado law, and many other states similarly don't give foster parents the right to automatically act as the parent. So in this scenario, for the foster parent to be able to sign the IEP, they would have had to have been appointed by either the school district or the court in the child welfare case as the educational decision maker, absent an explicit Colorado state law that gave them that authority. With the caseworker, the IDEIA is very, very clear that agency caseworkers, whether it's public or private, cannot sign IEPs. That's a no-no. Moreover, they specifically say that courts cannot appoint such caseworkers to be educational decision makers. So in no cases will a child welfare agency caseworker's signature on an IEP be valid. If you have a situation where a natural parent is AWOL, that you can't locate them, the important thing to do is to get either the school district or ask the court to appoint someone as the decision maker. A foster parent can be appointed unless it's explicitly prohibited by your state's law. I know we were in Pueblo yesterday doing this training, and they said that it was often the GAL in the case is appointed by the court to be the educational decision maker. So there are different options, and the individual decision maker can be someone with whom that the child doesn't live with. It doesn't necessarily have to be. It usually should be. It's probably the best person, but sometimes we have situations where other people are appropriate.